This podcast is brought to you by Kyoto Japan Automotive Group, a company which I've known personally for over 20 years, and your one-stop shop for tires, batteries, and auto parts. Visit their website at www.kyotojap.com for more details. My guest is an undisputed and recognized expert. Some of you listening might even know him already. We've been friends for many years, though I've never really understood what it is he actually does to earn his daily bread. He's an independent lawyer and member of the bars of England and Wales, New York and Geneva. He's also a pioneer in his field with many cross-cultural dispute specializations which reflect his interesting background. No doubt we'll learn about this as our conversation develops. He's an a graduate in English, that's the International School of Geneva, and a man of Oxford, which can't be bad because one of my sons went there. Jeremy Lack, welcome to the McKay Interview. Thanks for inviting me to your home, and thanks for making time for me.
Michael, it's a great pleasure to be here and an honor. I'm a big fan of your show and delighted to clean up any points you'd like to know about conflict resolution.
Jeremy, flattery will get you anywhere, but you're entitled to it because you're at home. Now, you're a professional mediator, but from what I know about you, came to arrive at where you are professionally today by way of a rather unusual route. Please tell me about that route.
So I started off with a classic training as barrister in England, and I started understanding that the appellate system, even going to the House of Lords for decision, even a House of Lords can get the law wrong. I was specializing in patent law at the time, so the combination of law and technology disputes, and I decided to go to America, and there it's jury trial. So you have 6 people who at times, you're not sure if they're understanding the technology. You're not even sure about the language. Are they able to keep up with the language? And you find that all the efforts, everything is concentrated on getting a judge to decide. Now, obviously, you're going to get at least 50% winners, 50% losers in these sorts of cases. Millions are spent. And what I discovered was, in fact, with IP cases, your best chances...
IP being intellectual property.
Intellectual property, yes, or technology cases. Your best chances were roughly 60% of winning in the best of cases. So there's a kind of a variable side to this. So much money at stake, so many lives at stake. And in the middle of all of this, I ended up doing a mediation training course because I had links back to Geneva, Switzerland. WIPO, back in 1994, was creating its arbitration mediation center.
And don't speak in alphabet soup because WIPO stands for the World
Intellectual Property Organization. So I'm back in New York at the time litigating, but because the WIPO, the World Intellectual Property Organization, is opening in 1994 this mediation arbitration center, the law firm sends me back here just to wave the flag. And although I didn't really appreciate the training, I have to be honest, I was a bad student, I learned something about mediation, even though as I left the course, I thought, I'll never use this. It's just not for real litigators. It's not for real lawyers. Around a year later, I find myself in a horrible negotiation situation for a client. Everything we'd prepared for a trial, everything we had has just disappeared because of some new prior art, and kind of in desperation more than anything else, I reach out and try to use some mediation techniques. So we were looking at a classic, we're going to enforce our patent rights, we're going to close down your company type of logic. Going into the room and just using some mediative techniques, which were focusing more on the business interests, looking to the future, rather than the legal positions of the parties, we ended up getting a joint venture. Something you would never have expected. And that kind of made me wake up and realize that litigation advocacy, positional bargaining, was not the only way to resolve conflict. So I went back, unfortunately for them, to the same trainers who gave me my first training, and I said, I've come to listen to this to you this time, and it really transformed my practice. So ever since '95, roughly, I've been using what I call appropriate dispute resolution as part of my practice, and it's this idea that not everything has to be a positional or an adjudicative system. In fact, in more and more cases, and depending on what you want to do, you can regain control of your conflict, whether it's a family conflict, a neighborhood conflict, a workplace conflict, a commercial conflict. I mean, conflict is in every aspect of our lives. You can take control of it and manage it better with an understanding of the choices you have. And that's what I mean by appropriate dispute resolution. It's not binary.
Jeremy, I've written in my notes that mediation sounds simple, but already it's beginning to sound a little bit complex because it comprises the people, the law, psychology, neuroscience, and society. So complexities obviously do arise, but can you just simplify some of these complexities for me and the listeners to explain why the subject fascinates you and why mediation is important?
Okay, so just to answer your question, what is mediation? It's actually very straightforward. It's simply negotiation with the help of a trusted third party. This is a person who can basically help the parties in their negotiation, but it's just a facilitated negotiation. What is surprising about it is that when you ask people what's the difference between negotiation and mediation, most people say there shouldn't be a difference. The truth is that you have much higher settlement rates with mediation. We can go into this later on in the interview.
A much higher rate of settlement.
You have higher satisfaction ratings. You have higher settlement rates. We can even talk about the neuroscience behind this, because working with a group of people at the University of Geneva, we've even identified parts of the brain that get activated in mediation that are not activated in negotiation.
Really?
So it's a really fascinating thing how it changes even the human brain. But what it basically does is it opens you to a sense of possibility. What can be done in this situation, rather than the simply grasping at positions and trying to, we have a kind of instinctive desire to enforce one's positions and explain to others why we are right and they are wrong. It's almost a very animalistic form of behavior that we have. Maybe we won't fight, but with words we'll try and convince. And so what mediation really is about is understanding that when you start to think about people's needs and interests looking to the future, and not just what happened in the past and who's right or wrong, you tend to get settlements in over 80% of cases. I've done probably over 400 disputes by now. Most of them are complex commercial. In less than 10 situations of those 400 have we not reached an agreement. The settlement rates for most ADR institutions are around 70 to 80% settlement
What kind of institutions?
ADR is appropriate dispute resolution institution.
I see. Okay.
So you have, and in Geneva we have the Swiss Arbitration Center, we have WIPO I mentioned before, we have FIDIC, we have several organizations here in Geneva all involved in dispute prevention resolution. And when they bring mediation into the process as an option, it works very well. I think the problem that people have is they tend to think, if I couldn't negotiate with the other side and settle through negotiation, my only choice is litigation. It seems to be kind of a binary process.
Yes.
People who work...
That's not the case.
Well, it's not the case. So obviously, when I say litigation, lawyers who work international immediately say, well, you don't litigate, you arbitrate an international case. That's for technical reasons about enforceability of judgments. But you don't have to just negotiate or arbitrate/litigate. In between, there's a whole range of possibilities. And I think that's where people forget that gradient of possibilities. To what extent do you want to keep control over the outcome? To what extent do you want to keep control over the costs? These are all very important variables. So what I would say today is that you need to make sure that any dispute you're involved in is being managed appropriately. And for appropriate, I have 7 criteria that I invite people to think about.
To even deal with that word, you need to have some knowledge before you can decide what is appropriate, sure.
And so let's look at what people, but this is all very straightforward because it's about people's procedural needs and interests. So let me break that down into 7 factors. The first one is obviously budget. How much is this going to cost me? Access to justice is too expensive in many countries, and even in Switzerland, if we compare 200,000, 300,000 Swiss franc dispute, it can be as much as 20% of the value of the dispute going to legal fees. So it's very disproportionately high for some, the cost of litigation. So the first thing is budget. The second issue is time. In today's commercial world, business people want to know that the outcome is available in 3 to 6 months. Your average litigation around the world is going to be more than a year. And in Switzerland, we're even hitting 3 to 4 years. It's an unbearably long period of time for courts to get resolution of a case.
Time is money.
So time is money, but it's also freezing you up in that you cannot move on until you know what the outcome is. So you've got time, you've got cost, and then you've got some other variables. One that people tend to underestimate is relationships. How important is either preserving the current relationship, improving it, or there are stakeholders who are judging, and it's a reputational issue, because if you are perceived as fighting with everybody, it can't be good for the other stakeholders, especially if you're in a small ecosystem that everybody knows everybody else, which can be the case, within trading or finance, whatever it is. And so you've got to think about relationships as a third criteria. So you've got time, you've got costs, you've got relationships. Now, with data today and technology, there's a whole question of discovery. What information do I have that the other party needs to know? And what information does the other party have that I need to know to be able to run this case effectively? And so whether you're from a common law or civil law jurisdiction, so one that's influenced by kind of old Roman law thinking or Napoleonic code of conduct, or whether you are looking at this in terms of British or US common law, the question really is, what information are you entitled to? And do you need to see that's relevant to the case? And in many cases, there's real sensitivity. So the area where I work, technology, you don't want to start giving your code source. You don't want to give your crown jewels to the other side to go through. So control of process can be very important for discovery. Do you need lawyers? Do they have to? Can I use my in-house counsel? Do I have to use external counsel? Do I have to use external counsel from this country? Can I use somebody from my corporate headquarters? These are all kinds of questions.
And Jeremy,
for process control.
These are a matter of judgment on your part, or are there other issues that impinge on the way in which you make that decision?
I'd say these are all business considerations. That you want to think about. Who knows best, the technology or the company or the case or the impact on the future? Because very often if you have a conflict, you want to be looking at it with a commercial sense as well. Even if it's a family, a divorce, whatever it is, you want to think about your future and the quality of the future you want to have. So this fourth criteria was mentioned, which is control of the process itself. What evidence do I need? Do I need lawyers? Do I need to submit briefs or not? Who needs to write them? These are all procedural questions. Then you've got as a fifth criteria, control of the outcome. Now, many people will say, why would you let a judge or three judges decide the outcome for you? This can be a make it or break it situation for your family, for your company, your livelihood. If you're a startup company, litigation can be a death knell. And so you would prefer to have, in many cases, control over outcome as well. So you've got control of process distinct from control of outcome. Then you've got issues of confidentiality as a sixth issue. Should people know you are in conflict? Do you want the way the conflict is being managed to be kind of known about, and the results? How do you want, if you have an agreement, a court order is normally a transparent public decision. A court order is in the public domain, so people will know you've won or lost, especially if you go on appeal. So confidentiality is an issue. And then finally, you have a seventh criteria, which is enforceability. In Geneva, we're an international community. And many businesses, if they have a conflict, yes, it can be internal to the organization, but very often it's with another organization outside of Switzerland or outside of Geneva. For reasons of enforceability, court judgments will not work because there's no automatic recognition and enforcement of a court judgment in one country to the other, unless you Lugano Convention, but let's put aside these technicalities. So you need a mechanism where you can get enforcement. That's why many people go to arbitration. But mediated settlement agreements under a new convention are also being increasingly recognized. And so if you have an agreement reached through a mediation, you can go and have that enforced and recognized almost with the strength of a legal decision. So these seven criteria of cost, time, relationship, control of process, control of outcome, confidentiality, and enforceability are all things that you know what you want by the time you've heard the choices, because you have a spectrum of choices. And with that, we can design the most appropriate dispute resolution process.
So there are
so it's not binary anymore, is what I'm saying.
So there are a number of moving parts there, Jeremy. And you mentioned the word technology when you were going through that list before. Tell me a little bit about how technology and neuroscience, and maybe even also artificial intelligence, which seems to come up in every sentence or paragraph these days. I mean, the genie's out of the lamp, that's true. But how best to manage all these technology and neuroscience from a commercial and business point of view? What's your advice on that?
Well, I've been very lucky because I started off looking at the brain in my studies. So I was studying physiological sciences at university before I completed my law degree. And that's what got me into patents. But at one stage when I was looking at mediations, I was struck by the higher settlement rates, the higher sense of satisfaction. And I was thinking there must be something going on in the human brain. And I went back and I went actually to one of my old tutors and I asked her the question, what do we know about a healthy human brain? Why is it that If a party makes an offer in negotiation, it will often get refused. Things that we can call today reactive devaluation. If you know the work of Daniel Kahneman, for example, Thinking Fast and Slow, you'll find there's a lot of kind of psychology and economics and how positional bargaining is affected by biases and emotions and so on. But what I did is I went back and started saying, what do we know about the human brain? And very little, as it turned out. And we're very fortunate in Geneva that we have the Centre Interfacultaire des Sciences Affectives, CISA for short. And it is an interdisciplinary center that is looking at emotions in many different ways. And so doing some work with them and some research, we found some fascinating things about differences in the human brain between negotiation and a facilitated negotiation with a third person at the table. There are certain areas of the brain, the nucleus accumbens being one of them, that we believe is more active. The technology is a bit primitive, so the way we measure brain, with fMRI and so on, is not a perfect science yet in many ways. However, we have, with social sciences, and experiments have been done going back to the 50s, plus now what we do, the shadows that we can see using modern technology and neuroscience, we are getting a much better understanding of the human brain in conflict. And to summarize it, as I see it today, we basically have patterns of behavior that are innate in us as animals. And there are 3 overlapping patterns of behavior. In a way, if you think of a computer and an operating system, our brain, which is the hardware, has 3 operating systems. One of them is social. Our sense of tribalism, do we feel in group or out of group? Just to give you an example, when you feel in group, you have an automatic sense of compassion and empathy for other people in your group. And you have kind of a more caring, a pro-social pattern of behavior when you feel in group. But if you feel out of group, and we prime people very often to feel out of group simply by defining one party as claimant and the other as defendant. So we're driving in that tribal wedge between them. You tend to drive an inability to be in compassion or to be able to have any empathy for the other side. And you tend to drive a more competitive form of behavior because it becomes more of a zero-sum game. So we've got these social heuristics that kick in the beginning. Linked to, but independently from social heuristics, you've got emotional heuristics. Am I afraid of the other side? Am I seeing them as a reward or a threat? We have parts of our brain that take over, that hijack cognitive thought in 0 to 300 milliseconds that are linked to notions of fear.
300 milliseconds.
0 to 300 milliseconds. I mean, for some it's even 17 milliseconds from what we've been able to measure. We're talking about fractions.
Simple English.
In the order, the time we think about stuff, it's already far too late to control it.
Sure.
A rational thought takes around 500 milliseconds to process. We're talking about pre-conscious thought. It's a very quick heuristic system. So we've got our social heuristics, our emotional heuristics, which finally give us, with whatever breadcrumbs are left in our brains in terms of oxygen, glucose, with cognitive thought. And so cognitive thought very often is held hostage by our social trends and innate polarities of do I feel in group, out of group, and our emotional polarities, do I feel safe or do I feel fear? And it's only depending on those 2 factors that we can really come in and think rationally about conflict and how we want to resolve it at times.
Well, there's a lot there to absorb, and that's just the first part of our program. My guest today is Jeremy Lack, one of Geneva's top dispute resolution lawyers. Jeremy, the need for effective dispute and conflict resolution thrusts itself on us today. I'm going to change direction slightly, but it could be that I'm just going down the wrong path. Please tell me if I'm mistakenly conflating 2 things. If I put Sudan, Ukraine, Southeast Asia, Haiti, the Near East into the mix of dispute resolution. Correct me if I'm wrong. How does it work?
Well, look, I actually think that it's all very much the same thing. And why? Because we always have human beings there at the end of the day. It's the same people with the same brains. And yes, you are correct that when you're looking at diplomacy and state-to-state disputes, especially intractable disputes, look at what's happening in Gaza and Israel right now in the Middle East. At the end of the day, it is the same form of behavior. The only thing is that it's just a more extreme level of disagreement.
Because of violence or not necessarily?
There is a scale that we use to measure conflict. There's basically a 9-level scale. 9 steps of conflict. And without going too much into the details of it, a lot of the conflicts that we see at the international level are levels 7, 8, or 9. They're towards the end of the spectrum.
To the end of the spectrum.
a level 9 conflict, which is the highest you can go, is a level where the destruction of the other side becomes a goal in and of itself. It's the one where the other side is an enemy, and they have to be either completely destroyed or controlled to a level that is unacceptable for the other side, clearly. And in those situations, you have zero compassion, zero empathy, that competitive behavior I was describing before. It's the only way of thinking about the conflict. And so when we know this from a neurophysiological level, the question is, why do we bring people to a negotiation table and expect positional bargaining to be successful? It can't be. So if we go back to Oslo Accords, if we look back at some of the things that have been successful with Aceh, or certain negotiations that have taken place here in Geneva that had a chance of success. If we look at the Egypt-Israeli peace accords, what made them possible was that they allowed the human side of leaders to kind of be recognize and re-engage. There are stories of Arafat and Rabin basically sharing pictures of their grandchildren and talking about what is the future we wish for them. The fact that they were able to kind of look at this as grandparents and try to think, what do we want for their children? For me, it sounds a bit touchy-feely, I understand that, but it does change the pattern of behavior between the two.
Well, what you say is correct. I mean, that's my observation now that I'm a grandfather, and I know you're a grandfather as well, that these things tend to be old men talking. They're not young men in their 30s or 40s. It's just a
commonality between us. I mean, it could be our love for Jamaican food, or it could be a number of things that we'll find in football teams. I find in many of my mediations, so for me, there are three sorts of situations of conflict. One where the people have just stopped speaking. Everything's happening through their lawyers, and they've lost that social contact. You've got other situations where it's really about technical issues, causation, what happened at this plant, why did this mine collapse, who's responsible for it, and everybody's pointing the finger at everybody else. Those are technical issues. And then you've got some which is just about numbers. Nobody really cares about the relationship, nobody really cares about what happens. They're just happy to settle on a number and walk away, and they hope they'll never have to meet one another again because they don't like one another's company, whatever it is. Those are all different types of conflict that require different sorts of processes. If people have not met in a while, I like to actually find an opportunity for them to re-engage in social and so a meal together I find is very effective. Now people say, are you crazy? I'm in conflict with these people. Why the hell would I want to have a meal with them? I don't want to be in the same room as them. So you've got that emotional level in there, or if a sense of betrayal. If the others on my side knew I was meeting with them, they would see me as a traitor. So you've got to manage these things as well. But more often than not, when I put people in a room together, and we do not talk about the substantive conflict itself, but other things, family, sports teams, anything, educations. I recently had a case.
That in your experience can happen. You're not seen as beating around the bush.
No, it really works.
It really works.
It's remarkable the transformation it has. I mean, I can just give you so many examples, but two CEOs of biotech companies having a multi-million dollar conflict, they have simply not met in the last 5 years. And when you get them together around a meal, for the first time they can connect and kind of allow the other's perspective and humanity to come in thinking, well, they're not complete idiots. They actually seem to make sense. Now that I understand their perspective a bit better, I start to understand their behavior a bit better and what their intentions were. Let's unpackage this a bit more, and they're a bit more patient to listen. And so just because people can listen, things change. So that's an example of two heads of corporations, but I've had this also with a head of state, where we had a dispute with a country, a state, and members from the government were at the negotiating table, and there was some technology. It was a technological dispute, and it turned out that the chief advising engineer to the government and the chief advisor engineer to the company, this was an investor-state kind of dispute where you had a country against a company who'd sold it commercial services. They'd both been to Stanford. And the fact that they had both been to Stanford as engineers, that both had the same courses, that had the same professor who they could share the same war stories of, that really broke the ice the night before during the dinner.
Understand that.
Now, you don't know that until you get to the event. I've had the most astonishing surprises of, even when there's no obvious common thread, people find they have a commonality. And so that happens just because you're breaking bread together. I mean, it's important to share the same meal. People are there together. It feels like it's a social experience where they can let down their guard a bit. And there's also know your so-called enemy. I don't believe in this pure concept of enemies, but know the person that you need to negotiate with is what I would say.
But tell me, I mean, this may sound like a simplistic question to you, Jeremy, but given all of what you said and the things that we've learned, how best then to avoid conflict in the first place? It just seems to me that this is not a secret, and we're all, in a way, grown-up adults. We look at these things, but we look at these things sometimes through a very jaundiced lens. Is that correct?
Well, we look at things, I wouldn't even say through a jaundiced lens, but through an emotional lens. That feeling that we are right, they are wrong. You know, we're on the team that is the good team, and they are on the bad team by definition because they don't accept our view of things. That is already the first problem. So how do you avoid it? I think is the first thing is to realize that nobody sees themselves as wrong. Everybody feels justified in the positions they've taken, and when you look at the world through their perception of the past, what happened, they will always find a rationale for why they are completely just in what they are doing and they are right. Even people I've found have broken the law have said, but I had no other alternative given how the circumstances were stacked against me. They will rationalize anything to themselves to justify their behavior. None of us like to see ourselves as bad people. And so what can we do when just a negotiation goes wrong? I think it's the same principles. Obviously, bringing a third person we know helps, but maybe you're not ready yet to admit that you need help, or there's a lot of posturing. You know, even a lot of lawyers, when I speak to them about bringing a mediator, they say, why would I do that? I'm a fantastic negotiator. I don't need a lawyer, a mediator. Or even worse, they say to me, I try to negotiate. What is the mediator going to add as value now? If I couldn't get this to settle, what is the mediator going to do? And so with a negotiation, you also have egociation, just drop the N. But, you do have a lot of that to understand. And I think what we've got to do is park our egos at the door and be prepared to just say for a second, let me try and do some perspective taking. Let me put myself in my, in the adversarial party's shoes for a moment and just try and revisit it from their perspective. And it's not just the past, who did what and, who was right or wrong, but try and look at it in terms of what are their needs and interests looking to the future. I think the more we're able to step into the shoes of the people we need to negotiate with, this is for generic negotiation. It's not just conflict. This is to prevent conflict. I do sometimes mediation of joint ventures or strategic alliances where there is no dispute, but people are finding it difficult to close or to try and work out what happens if something goes wrong when you create this joint venture relationship. It's the same kind of fear of the what ifs. There you can basically start to think through, well, what are the needs and interests? And can we find a process that will always meet the needs and interests of the parties? Many outcomes can be win-win. It's only positions that tend to be antagonistic. You can't, if you say, we got to go to a Chinese restaurant tonight, and I say, no, we got to go to an Italian restaurant tonight, and it turns into a conflictual topic. This used to happen with my children, for example, if we were trying to go out deciding who's going to have dinner. These things can escalate bizarrely about, who's right and who's wrong about something like this. The point is everybody has a need to go and have a nice dinner or whatever it is, a special celebration. And so when you look at the needs and interests behind the positions, they are very seldom in conflict. And so you can find any restaurant that is going to be a fun, good meal, whatever, and these issues disappear. And I know that sounds childish looking at a restaurant example, but I can tell you that I've seen this with governments, states, I've seen this with corporations. It's the same logic. People just get so focused on the position and wanting to convince the other of the rightness, the correctness of their position, that they kind of forget that let's look at the needs and interests looking to the future for both of us. And what is a win-win solution that is going to allow you to continue with your business and allow me? Because at the end of the day, many conflicts, it's the same needs and interests. You want to, typically it's financial. You need to increase your revenues, decrease your costs, your market share, your profitability, having stable employees. Those are typical commercial needs and interests that all companies have. And so you can find solutions if you just look at it at that level.
And in closing, Jeremy, once in it, what are the best steps to get out of it, to get out of this dispute? Are they essentially almost codified, or is it a combination of being a set of prescribed processes that people like you've learned over experience, or do you really need to have a bespoke approach?
Look, I think developing a bespoke approach is not obvious for a person who's getting into conflict for the first time. You can't kind of be there and say, oh, well, I heard the McKay interview and now I know what to do differently. On the other hand, I think what you can understand is that your negotiation is not working. But basically going to litigation arbitration on its own is basically the choice between the pox and cholera, so to speak. You want something in between. You want to think of, is there something where I can get to a solution? And that's where I think there's a lot to be done. I mean, the Canton of Geneva has an incredible program now. Anybody who's in the state of Geneva who has a dispute, whether it's commercial or civil or neighbor or whatever, the courts of Geneva will pay up to 7.5 hours of a free mediator, time for a mediator, renewable 3 more times. So in fact, you're getting 30 hours of potential mediation services paid for by the state of Geneva, and that's something people just don't know. So if you have a conflict and you're in Geneva and you're lucky enough to have access to this program, you could go and say, do you want to mediate? Now, the other side might feel, I'm not weak, I'm not in a strong position, I don't need to mediate because I know I'm going to win in court, whatever there is, but you've got nothing to lose. And I think that's really what it's about. Another thing I would suggest to people is not only to be aware of your procedural choices, but I would say that another thing to do is to think more in terms of what is it that you are looking in terms of your social community? What matters to you in terms of the people that are looking at this conflict and want to resolve it? And the truth is there's always a faster, cheaper, better way of resolving a conflict. And you just need to think through them and get the right help. And I think for lawyers, it's also a big change that we're asking for lawyers these days, because in many countries, lawyers are still very much used to, the bleak house approach, and keep the case going, and it can go on for a very long period of time. But lawyers, I think, are also beginning to understand that you need to settle.
Before we finish, you have to explain the bleak house approach for those of us who are not really sure what that means.
I'm sorry, that's a Dickens novel.
I know the novel. I've read the book, but just tell me a little bit more about that.
It's just one of these intractable family disputes. It goes on for 3 generations, and the only people who basically make money off it are the barristers, the lawyers, the solicitors, who are 3 generations later keeping the case alive with motions.
So Dickens lovers would have understood what you meant.
Dickens lovers hopefully would have understood what I meant. But it's this concept that, in a conflict, the only people who benefit from it, and people will say this, are the lawyers. I don't think that's quite fair to lawyers. Most of us really want to help our clients resolve their disputes and get to faster, cheaper, better outcomes. And there are a number of things. There's even now litigation financing, for example. If you can't afford litigation, you have certain funds. You have some even in the Geneva area for many years that are specializing in how to help people finance their disputes. And you even have now a new model altogether of funds that will pay for mediations, and that will help. They won't work with one of the parties, a claimant, saying, you got a strong case, we'll back your claim against another party. What they will do is say, look, we'll convene all the disputants and we'll help them jointly do a diagnosis of what type of conflict do you have, what are your procedural needs and interests. We'll help you design a bespoke process. And it doesn't have to be an either or. You can use arbitration in combination with mediation very effectively. I've seen that very often. Or we have something different in something called conciliation, which people confuse with mediation. It's not the same thing, because a conciliator is normally a judge. It's a very limited period of time. It's basically a non-binding arbitration by a judge, whereas mediation is much more about the subjective needs and interests looking to the future. But you can combine all of these parts to a bespoke process that takes into account your social needs, your budgets, all the things we were talking about before, and you can get a more than 90% settlement rate if you just combine these things. So I think it's more about stepping back, understanding that yes, your negotiation might have failed. Another thing is important: know your alternative to a negotiation. If you're not going to negotiate, understand your best alternative, but also be aware of your worst alternative, because people very often only focus on the best alternative, and there's a worst alternative out there as well, which is losing, for example, in a court. And once you've got a good understanding of your best and worst alternatives, and that your negotiation is not going well, just go back and think of how else can I resolve it or prevent it from escalating further. And you can do that in more than 95% of cases.
Well, it's just fascinating. I mean, I came into this conversation not knowing much at all, and you really opened the lid a little bit on that, because it is complicated, and yet at the same time there are aspects of what you said which sound so encouraging, and that maybe many people in the general public who are very important in this discussion just simply probably didn't know until they listened to you talk this morning. Thank you very much, Jeremy. I mean, you've been really very, very helpful.
Michael,
my guest today has been Jeremy Lack, one of Geneva's, in fact, he's one of Switzerland's top dispute resolution lawyers. Jeremy, thank you.
Michael, thank you so much. It's always a pleasure being with you, and to be on your show is a real honor again. Thanks a lot.
Thank you, Jeremy. Thanks for listening to the McKay Interview podcast, brought to you by Kyoto Japan Automotive Group, a company which I've known personally for over 20 years, and your one-stop shop for tires, batteries and auto parts. Visit their website at www.kyotojap.com for more details. And you can find more podcasts on Anchor FM. Just Google McKay Interview Anchor FM. Thanks again for listening.